Thank you very much, Naina. And I'm just going to begin by, I know Naina and Jeffrey never like to be thanked, but nevertheless, I am going to thank them for inviting me.
We forbid it. Not that we don't like it, we completely forbid it.
All right. I'm going to say thank you, and I'm going to move on to my presentation. I'm going to talk about state responsibility for genocide, both and look at essentially the legacy of the work done at the ICTY and the ICTR. Genocide is a contested term. It is contested for three reasons. Firstly, what people wish genocide to mean. Second, what it actually is as a legal concept and crime. And third, because of how and when it is deemed to apply, given that many people will have a differing perspectives of when they consider a situation to be genocide. I like to think of it as more akin to a paradox. Many people, if asked, will tell you precisely what they believe it to mean. Few, including lawyers, have an informed understanding of it in a strictly legal sense. Now, you might say, well, why is a legal sense relevant? And the legal sense is important because it is a crime, and it is a crime where a majority, almost unanimity in the countries of the world have agreed that genocide should not be committed. And we are all familiar with the refrain, and we hear it often, of never again. So you might ask, well, given the consensus among states on its prohibition, why is there the contestation? Why is there the difficulty? And the reason for the conceptual difficulty is that it is a crime defined in an international treaty which came about after intense negotiations among states. The same states, of course, in most cases were subsequently willing to sign up to the provisions of the treaty they themselves had negotiated. And you see then the inherent conflict. The context, of course, were the horrific atrocities committed against the Jews of Europe, the Roma, the Sinti, and other groups at the hands of the Axis powers. Now, one would say, both then and now, that the atrocities that were committed against the Jews and other groups were genocide. And it was that historic instance of the atrocity crimes where the popular conception of genocide emanates. And essentially that is, in a popular conception, the annihilation of a large number of people. But of course, that's not what genocide is precisely. If you build on this popular conception of genocide, you might say it is the annihilation or the elimination or the destruction of a large number of people from a particular group. And that will provide a little bit more clarity. Yet the formal definition of genocide is even more precise than that. It is, as we've heard in the lectures this week so far, it is the commission of prohibited acts with an intent to destroy in whole or in part a national, racial, religious, or ethnic group. The definition is not only precise, but it is deliberately exhaustive. There are 5 prohibited acts and no others. You've heard what those 5 prohibited acts are. They are killings, serious bodily and mental harm. There are conditions of life calculated to destroy, measures intended to restrict births within a particular group, and there is a transfer of children from one group to another. There are no other crimes which constitute genocide, or acts to be more precise. There are only 4 protected groups. There are no others: racial, ethnic, religious, or national groups. States specifically did not wish to include social groups. They did not wish to include political groups. They did not wish to include informal associations or cultural associations of people and so on, not least because they themselves may have fallen foul of the law, both when you look at their actions in the past and their subsequent actions in the future after the signing of the convention in 1948. Now, each of the terms within the definition I've just recited have been further defined, albeit still subject to serious contestation. The definition has developed through the interpretation of the Genocide Convention itself. It's come about in clarification in international and domestic instruments and treaties. And of course, it's been developed very extensively, in particular from the jurisprudence that has emanated from the international criminal tribunals relating to the former Yugoslavia and Rwanda, the ICTY and the ICTR respectively. It's probably a helpful point to have a reminder that the very first convictions for genocide were not at the Nuremberg trials. The concept was too controversial, it was too misunderstood, and arguably the processes and the procedures at Nuremberg were far too removed from modern conceptions of justice, or even a modern conception of what the law should and does entail. In fact, it was not until 1998 when the ICTR convicted Jean-Paul Akayasu for genocide. That was the very first conviction for genocide. And it was not until 2001 that the ICTY convicted General Krstić of genocide in Srebrenica. Yet the convention itself was signed in 1948. That brings me to the question of responsibility. The Genocide Convention creates a dual responsibility upon both individuals and states. Article 3 of the Genocide Convention says the following acts are punishable: genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. Now, it's easy to see how that applies, like most other criminal acts or crimes, to individuals. Some of you may well recall the famous line in the Nuremberg judgment of 1946, when it was argued by one of the parties that international law concerns the actions of sovereign states and not individuals. And the court replied in the following manner: crimes against international law are committed by men, not abstract entities. And indeed, that statement still rings true today, and still the vast majority of perpetrators of mass atrocity crimes are men. Now, by contrast, push forward almost half a century later, in the case between Bosnia and Serbia at the International Court of Justice, a judgment which was issued in 2007, Serbia argued the exact opposite. It said that individuals commit crimes, not states. And you may well ask, yes, how does a state form an intent to commit genocide? And how can a state really be responsible for a crime? Now, the responsibility under the Genocide Convention is very broad and it is very expansive. States can have attributed to it the acts of its own agents, officials, and organs, and also complicity by its agents, organs, and officials in the acts of others, i.e., non-state actors falling within their jurisdiction. States under the Convention have a duty to prevent genocide. States under the Convention have a duty to punish perpetrators of genocide. Obviously, that would mean that genocide would have had to have occurred in order for a perpetrator to be punished, or at least have attempted or conspired to possible acts of genocide. And states also have a duty to enact the necessary legislation to give effect to the provisions of the Genocide Convention, and also to provide effective penalties for persons found guilty of genocide. And that really brings me to the heart of my presentation. Since 1946, when the Nuremberg judgment was issued, or indeed since 1948, when the Genocide Convention was adopted, there have only been 2 contentious cases at the International Court of Justice. That means when one state brings another before the court arguing that it has failed in its duty to interpret or apply or fulfill its obligations under the Genocide Convention, under Article 9 of the Convention itself. By contentious cases, I mean one party believes it is the injured state, i.e. the state where the acts have occurred, at the hands of another state, which is a party to the Genocide Convention. Many powerful states also maintain reservations in even allowing another state to bring it before the International Court of Justice for failing its responsibilities or obligations under the convention. Yet there are two considerations that I have when it comes to these failures. First, the prohibition on the commission of genocide is a peremptory norm of international law. What does that mean? It means it is a crime that is considered so heinous that it is not just part of a treaty, but it is part of customary international law. That is, states have prescribed genocide, and also in practice, they have either declared or considered genocide to be beyond the pale. And also, it is part of international law that no country may derogate from the prohibition on genocide. It is an absolute prohibition. Second, the Genocide Convention is clear, as is the jurisprudence, that the prohibition of genocide is also erga omnes and erga omnes partes. By that we mean it is so fundamental that each state owes a duty to each other and also owes a duty to the world at large to not commit genocide, to prevent it where it is either about to occur or is occurring, and to punish it when it does occur. Yet that brings into consideration three further factors. First, there has only been one state to have ever invoked that duty by bringing an action against another state, even though it is not an injured party. So Gambia in 2019, for the very first time in history, brought a state which was completely unrelated to it. It had no interest other than a legal interest and concern that Myanmar was allegedly committing genocide against the Rohingya population there, and therefore it made an application to the International Court of Justice, alleging that Myanmar had failed in its interpretation, in its application and fulfillment of the provisions of the Genocide Convention, which it signed and ratified without reservation. Second, never has the UN Security Council invoked Chapter 7 to attempt to hold a state accountable for genocide. And third, never have the 5 agencies of the United Nations, its 15 specialized agencies, its 1 related body, ever invoke the special procedures available to them in order to ask the International Court of Justice to issue an advisory opinion on the question of whether genocide has occurred or not in a particular country. And all the while, alleged genocides continue to be committed. We ask how many, not when, and we say, rhetorically it seems, never again each time genocide occurs. And we wonder, when genocide has been committed and individuals charged and convicted, how exactly were they able to do so, given the duties of states in the convention, and in particular, given that they did so apparently without the power and machinery of a state. States which are the drafters of the convention, states which are the objects of the convention, states which are the duty bearers of the convention, and indeed all other international instruments. And states, most importantly, who command the sole authority, the sole power, and sole discretion to use lawful force, and also to sanction, legitimately they would say, violence both domestically and internationally. My underlying premise is this, is that to carry out genocide, almost in every single case, you need a state to act or omit to act when it is necessary. hence the duty to prohibit genocide, hence the duty to prevent genocide, and hence the duty to punish genocide when it occurs, as set out in the provisions of the Genocide Convention itself. So to conclude, I have two reflections which I would like to leave you with. The first is that states have not only a legal interest, but a moral and ethical imperative to ensure that the peremptory norms of international law, and principally and predominantly the prohibition on genocide, ought to be upheld, and that obligations owed to the international community as a whole to prohibit, prevent, and punish genocide ought to be enforced. And second, for the prohibition of genocide to have any meaning at all, not least for victims and survivors of rights violations for crimes, humanity must act in concert through their state representatives to ensure that the rights and obligations and duties under the Convention are interpreted, applied, and fulfilled without reservation. Each of us ought to hold our state representatives to account. The lessons of the heinous crimes suffered by those in Bosnia and Herzegovina, and in particular the Bosnian Muslims of Srebrenica 25 years ago, ought to be more than enough for us to take heed and for all of us to reaffirm our commitments thereof. Thank you very much.
I was actually reading, I think, Aarif, that your paper that you posted in the chat yesterday. I was reading that and also a couple of things that was linked to it as well, relating to, I think it was the Karadzic judgment. And the thing I found quite interesting, I guess, from your talk and also from that article that you wrote, and I guess it's a general question for yourself and Jeffrey and Nena, just that if you feel that in defining the scope of the joint criminal enterprise within Srebrenica, and the way that it had to be defined within the parameters of the law, do you think that was counterproductive to the wider narrative about genocide? Do you think there was any ways that, because it was so it was so focused on like how big the group was within the part of the group within the wider group, and there was so many sort of fine points that it was turning on, do you think any of those was counterproductive at all?
I don't know if Nena wants to go first. Or
No, I like listening to you. I bore myself always.
I mean, I would probably separate out your questions. So you've talked about joint criminal enterprise. And of course, when we talk about joint criminal enterprise, we are talking about individual criminal responsibility. So we are talking about the liability of individuals for the alleged acts. So joint criminal enterprise is a concept that was created partly because of the problems of trying to both charge and prosecute crimes such as genocide, where you arguably can't get genocide. So I'll give you an example. In theory, let's say you have an area or a country that has 12 people. Let's say it has 3 ethnic groups in that country of 12 people. One person says, I'm going to go kill X person from one of the ethnic groups. So that's one of 4 people, basically. He goes and kills, he says, I want to destroy this entirety of the group. He goes out, he goes and kills somebody intentionally, and he does so with an intent to destroy the entirety of the group. That is genocide. Whether he kills a person or not, it doesn't really matter. If you go out and do it, that is genocide. Now, when you extrapolate that very basic example to a vast country, you're going to have difficulty. But because let's say you have an individual in a street that has an intent to destroy all people of a particular ethnic group. He can go out in his street and start killing people in his street. Will that be genocide? Because that person can't feasibly go around and kill everybody. He's just killing everybody in his street who he considers of a particular ethnic group. He wishes to destroy the group, but in reality, in theory, you might say that's genocide. But of course, in reality, it isn't. And so when we talk about genocide, when we talk about state involvement, we are talking about multiplicities of actors, people in the military, in politics, and elsewhere. And you automatically are going to start talking about state agents, officials, etc. And obviously, that's what the concept of joint criminal enterprise was intended to cover. But at the end of the day, if you have a criminal trial and process, you will only be talking about individual convictions. And that's why Bosnia took Serbia to the ICJ, to ask that the ICJ considers the question of state responsibility. And indeed, in respect of Serbia, it didn't say Serbia committed genocide, but it said, yes, it failed in respect of some of its duties. So it's important to separate out these two types of responsibility. As to the question of genocide in Serbia, I mean, you saw the discussion with Andrew yesterday, and there is a legitimate discussion to be had of asking the question of when somebody has an intent to destroy a part of a protected group, how small do you go in respect of that part before the concept becomes meaningless? And there will be many, many practitioners who believe that when you go into such a small part of the group, that the concept does become meaningless, because the idea that this is an intent to destroy the entirety of a group or a substantial part of it. And what is substantial? And inevitably, you will have people saying, well, Srebrenica was decided wrongly, and we ought to now roll back time, and we ought to go back to this conception of genocide that was really, we were talking about millions of people being killed. But I think it's a misguided conception. The reason it's misguided is you will have groups that, for instance, only number a few people. Some Amazonian tribes might only number 100, 150 people. And if you eliminate the Amazonian tribe, you have committed, and you intend to destroy them all, you have committed genocide. If you have a group of people and you target, for instance, the religious leadership, let's say it's a religious group, so you target all the religious leaders, you target all their cultural leaders, you target all their intellectuals, you target all the symbols which allow them to constitute and continue as a group. So for instance, a particular town or region, you go and say, we're going to eliminate all those people. You want to set a symbolic, perhaps, example to the rest of the group of what will happen to them. Then you start to move away from the numbers, and you start to think, well, yes, could that be that we've targeted a substantial part by targeting this handful, because that in a way shows our intent. And essentially that's what the judges were doing in the Srebrenica cases, is that they were moving away from the starting point, which are the absolute and relative numbers of the group, to then thinking of the actual circumstances around which the acts were committed. What areas did the perpetrators control? You can only commit genocide in areas you control. You can't commit genocide elsewhere. By 1995, the Serbs probably only controlled about less than a third of the territory by that stage. So, they couldn't have gone and killed all the men in all the other municipalities by that stage. Srebrenica was on the border. It had symbolic significance. It was a UN safe area. There were lots of other factors that were in play, and that's why it became difficult to say it was not genocide. But obviously the problem comes now that if you've set that precedent saying these factors can make a situation substantial, a part of the group is targeted which is substantial, and you can move away from the numbers, then we probably ought to apply that standard, that jurisprudence, consistently. And if you want to apply that consistently, then you have to rethink what it is you believe genocide to be, because otherwise the concept does become meaningless, because you've then set different standards and you apply the rules differently in different instances when it's not justified.
Adam?
Yeah, I hope this is all right, but I've got sort of three questions. I'm hoping one of them
No problem at all. Go ahead.
Long. So Aarif, so on the first one, in that last answer you gave, you focused heavily on the word substantial part. However, in the Rome Statute, it doesn't specifically say substantial. Are you basing the the use of the word substantial on case law that's been developed in this process. Secondly, I thought the example with Gambia and Myanmar is really interesting, because obviously this is looking to the enforcement of the international obligations to prevent genocide. What do you think is the most effective way of enacting this enforcement? Do we rely on the Gambia trial setting a precedent for other states, whether they be completely unrelated or not, to try and pull up states for committing genocide? Or do we need some sort of international body to proactively prosecute in this manner? And then finally, I hope this is sort of the right place, but I'm not sure whether this is jumping the gun a bit. So I saw you have a new book coming out on constitutional design, which sounds really interesting. Are you able to give sort of insights as to what you think the most effective way of designing a constitution is to prevent this sort of atrocity happening in future? Sorry, that was quite a lot.
Okay, just to remind you, coming from a communist education system, constitution is nothing else than the tool of a ruling elite to reinforce their power positions. So it is my class addition to what constitution does for us. It's a ruling class tool. But anyway, wonderful questions. So Aarif?
Yes, to take your first question. So of course the Rome Statute essentially incorporates almost identically the provisions of the Genocide Convention, as do most other international instruments giving effect to the Genocide Convention. So when it comes to the question of substantiality, the reason that question arises is, of course, when you have an intent to destroy, the mens rea, specific intent to destroy a group in part, you need to interpret what a part means, and the interpretation has come about as a result of jurisprudence primarily developed at the ICTY and ICTR. So you can go and look up the jurisprudence and exactly what the test is of substantiality. So you find it there. You won't find it in the Rome Statute because the ICC hasn't considered the question. So it may develop jurisprudence in years to come if there is a International Criminal Court in years to come. Second question, an effective way of enforcement and giving effect to the Genocide Convention. Well, it's a very difficult one, because if it took half a century for a state to consider to enforce the obligations erga omnes partes on the Genocide Convention, you wonder when will the next instance arise. The reason Gambia brought Myanmar to the ICJ is very complicated and very complex. And also it came about because a number of factors just happened to coincide. Political factors, factors completely unrelated to the commission of genocide in Myanmar. They all had coincided. There were individuals involved who cared about the issue and happened to be in very significant political positions in particular countries at the right time, at the right moment. And that's the reason it came about. I have to say slightly pessimistically, it's rarely that a state on a purely principled stance will bring another state alleging that they've committed genocide or are responsible for genocide, because states don't just, they just don't function purely on the basis of principle and values. You'd hope that they do, and we obviously try and work towards that effort that they do, but there'll be realpolitik and other interests and other considerations involved. As to an international body to prosecute genocide, that would be lovely, but if you think about the difficulty in having the Genocide Convention even agreed to this bare minimum of a definition, and even all the contestation that it still involves, the idea of getting a majority of states, particularly when the International Criminal Court is under such attack from all corners in the world, particularly powerful states, is probably not in our lifetimes, but we could still try. As to the question of constitutional design, I've got a lecture on Monday, so if I may, I'll park that question till Monday, if that's all right.
Yeah, certainly. No, so I wasn't sure of the schedule. Thank you very much.
Can I intervene just very briefly as to the previous questioner? Definitions of genocide, we're stuck with the definition we've got. It isn't going to change. And efforts to moderate it or modulate it by non-legal language, and Nick Vetch, who's here, and I were present at an entirely different event yesterday where we saw somebody trying to expand it in an informal way and almost bound to fail. We're stuck with the definition. We're in early stages. It's only really 20 odd years since courts have been dealing with it in an interpretive way. We're in the early stages. And so I'm afraid it's a question of wait and see, but stick to the law. Not something you might want to do, not something I might want to do, but we have to do it. Second very quick point is, for those of you interested in the question of part, but also interested in the question of whether an individual can commit genocide, the case of Jelicic, Jelisic, at the Yugoslav tribunal, and also a case in Germany from well before that period, show that, of course, an individual can be charged with genocide, and in respect of, in the German case, one killing. In the case of Jelicic, a relatively limited number of absolutely horrifying killings, and with an intent to destroy a comparatively small part of a comparatively small part of the Bosnian population. So just for those of you interested in digging deeper, Jelicic, Jelisic, look to the appeal court judgment. The case is very interesting also for the intervention within the trial process of improper political considerations, but that's not for now. Sorry to intervene. Next question.
Yeah. So my camera's
Sapan,
on,
yes.
so I can't put
Go
up
ahead,
my
Sapan. No problem. We're listening.
Yeah, this is a question for Aarif mostly, but both of you, which is, what under the Genocide Convention are the reparations or remedies available? So finding of genocide is made, what kind of compensation, as it were, can the state obtain? And then following on from that, why was it that the ICJ didn't mandate that Serbia pay Bosnia any monetary compensation?
Aarif, tell us.
Well, I'd firstly recommend have a very detailed read of the convention itself. It's very short and it's a very worthwhile read. It should be in the pre-reading. As to reparation remedies, there are no specified reparations or remedies. However, as I've said, the convention itself is extremely broad, and essentially, if a case is brought before the ICJ, there is nothing to stop it, or there is nothing limiting the possibility of reparations and remedies in any which way it wishes. So you can have, obviously, the immediate remedy often asked for, as Bosnia did in the case of Serbia, was an immediate cessation of all acts, all alleged acts of genocide and all other crimes in the territory. And the court very quickly did give a ruling to that effect. So you have an interim measure saying genocidal acts must stop immediately. And you've had the exact same thing happen in the case of Gambia and Myanmar. So that is the very first, of course, remedy, is that you must stop, cease and desist any acts of genocide. As to whether if a state has been found to have committed genocide, or let's say the act of genocide is attributed to the state, or it failed in its duty to prevent, or it failed in its duty to punish, then the ICJ can, in theory, give any decision as to just satisfaction as it wishes, from individual measures that might include compensation, money, all sorts of other things, general measures, the passing of laws and legislation to prevent it in future, to give guarantees of non-repetition, to have reparations commissions. It could even, in theory, ask for truth and reconciliation commissions. There's nothing to stop the ICJ doing any of that, because it would give effect to the provisions of the Genocide Convention. as to the case of Bosnia and Serbia and compensation, to be honest, from the top of my head, I don't know the answer to that question. Nena might know, but I believe it was a very restricted finding on responsibility. It wasn't an expansive finding on responsibility, and therefore that might have impacted the decision it made as to remedies as such. And usually the remedy of most importance for most constituencies of people is a declaration that genocide was committed, and then everything else flows from that.
I think on the question of remedy, you're right. It was limited in its factual findings, regarded by many as ludicrously limited and unrealistic. And the minimum it was obliged to find, given it is a politicalized or politicized court. And that is a sad reality. Gambia also is really encouraging, but it could ultimately turn out to be really dispiriting. So far, we've only had preliminary rulings, protective measures. It looks as though, I think, Aarif may know better or disagree, but it looks as though generally the jurisdiction is not going to be challenged, but it could be in due course that the whole question of Gambia's right to bring this action, jurisdiction being granted in that way, could yet be challenged. And the political vectors operating on a court like the ICJ, not to mess with big countries in a way that might offend politicians, I'm afraid, is always likely to be a possibility. Sad, true.
Yeah, so you, Aarif and Jeffrey, and you, Adam, tackled some extremely important issues. One is, yes, the Bosnia and Herzegovina as a state filed a lawsuit against Serbia for genocide in '93. In '93, when did Srebrenica happen? Think about it. So why should Bosnia and Herzegovina ever file lawsuit against Serbia for genocide, while the finding that it was a genocide for all courts we know is for '95? Think about it. But what is important, what Aarif said for both cases, Myanmar and Bosnia and Herzegovina, the moment ICJ got on the record the lawsuit application, it said in an official document that we used as evidence for notice. All Serb politicians were put on notice by ICJ, where it says that Serbia and Serb forces have to refrain from committing genocide in Bosnia and Herzegovina. Can you imagine what a powerful evidence it was in our hands? So it was in March '93 that ICJ said that in so many words. And then two UN resolutions from April '93, they say that Serbia should stop involvement in Bosnian war, otherwise it will be responsible for genocide. These are extremely powerful pieces of evidence, actually. ICJ and UN ask parties to prevent genocide. So listen to this. In May '92, 1 year before, UN issues a full package of sanctions against Serbia, i.e. Federal Yugoslavia, which Serbia formed at that moment in Montenegro, saying that sanctions will be in power as long as Serbia is involved in the war in Bosnia and Herzegovina. And then this ongoing evidentiary material from the highest places in the world not only do not prevent Serbia to continue genocide, but the culmination of these genocidal actions in Srebrenica '95, and now we have the rulings from ICTY that completely erases the responsibility of Serbia through individuals, Serbian officials, and Serbia as a state, and ICTY and ICJ. So this is what we have as a result of legal response to genocide through judgments. I will show you in a little while the charts that show you much more how inadequate the genocide judgments are. So we'll come to this point a little bit later when you can follow it in a visual sort of way. Second thing is about reparations. You know that in individual criminal trials, there is no point that a plaintiff of a survivor of genocide or family member would use the genocide judgment against Karadzic or Mladic to get reparation, because in a criminal law, what you will get from individuals? Well, hardly anything, because even if they stole so much money, they hid it well in larger families. So victims and survivors are usually left to get reparations from state institutions. So this is why ICJ lawsuits are so important, because that would open any finding that Serbia, as any other state, was responsible for genocidal crimes of a certain protected group. That would be a beginning of starting a class actions even at another rule, a court, of course, you know, because ICJ is not court for this sort of thing. So what Jeffrey and Aarif said is that in the judgment from 2007, in a lawsuit Bosnia-Herzegovina versus Serbia on genocide, there was established that the genocide took place in Serbia, but the ICJ used only ICTY records, which are still incomplete. You know, we did not have any major genocide judgment. You didn't have a Karadzic genocide judgment, you did not have Mladic genocide judgment, and so forth, etc. But even then, they said that Serbia was not found directly involved in planning and instigating genocide, but Serbia was found guilty, not preventing, or responsible, not guilty, preventing genocide. And some of our colleagues, including lawyers in Bosnia-Herzegovina, they say it would be maybe enough as a finding to start lawsuits, class action lawsuits, and try to get a compensation for losses from Serbia. Many of our colleagues from Bosnia are still surprised why it did not happen. Maybe Jeffrey is right, maybe it was just not enough, but the law is only interesting as a tool if we really check it in the court. So unfortunately, no one did it so far, so we wouldn't know how it would happen. As you know, in the Dutch system, Hassan's case was successful. So you can go to the court against the state, and yes, Dutch state paid reparation, but Dutch state is very low on the amounts of reparation, so it was extremely symbolic. But still, it does and can work out. Only these victims are traumatized, very often have to struggle for their lives. They're not so savvy in finding the ways how to do it. And as Hassan said, he was approached by this Dutch lawyer, Elizabeth Zechel, who told him, okay, we are going to do it. And it took them 7 years just to confirm jurisdiction, that the Dutch court they approached was the court that could take that case on. So, you know, for a victim, I think it's a discouraging, long and bumpy road. I'm not so surprised that this particular cause is not very often taken. And it left Hassan very traumatized. If you ask Hassan, when would he repeat this, I think he would have second thoughts, because can you imagine how awful it was for him when the case was taken on, but his mother was took off the list as a victim. You know, so as a victim, you have to go through completely different process of potential new trauma. And many victims are not prepared for that, are ready for that.
Next question. Silence.
If there are no questions, I will then show you my chart, because I'm waiting all the time.
Aarif has another question of himself.
Okay, Aarif.
I think there is another question somebody's asked, but I just wanted to follow up on something Jeffrey said about Jelačić, and what Nena has just said is a helpful way to think about genocide crimes is to when you're talking about individual criminal responsibility, is to consider the perpetrators in three classes. So you consider low-level perpetrators. So these are people who do the torture, who fire the guns, etc. These are people on the ground literally committing the acts of genocide. So killing, serious bodily mental harm, conditions of life calculated to destroy, which means concentration camp-like conditions. So these were in Bosnia, obviously in Prijedor and Omarska and other places, you had camps where men and women were held, where they were tortured and ill-treated, etc. And then the other two acts are measures intended to restrict births, and you can do that in many different ways, and transfer of children from one group to another. So there'll be people on the ground doing this, and then you move up one other level, and you're looking at mid-level perpetrators. So these are commanders, officials, not high up in offices, but in police stations, in charge of small units in the army, bureaucrats at a municipality, at a local level in municipalities. So these are the kind of people who help facilitate the crimes of the low-level perpetrators. And then you look at the very top. These are the generals, the military commanders, the politicians, the people inciting acts of genocide. These are what you might normally consider the acts, the agents, the organs, the officials, usually of the state. Now, the problem is when you have crimes as were committed in the former Yugoslavia, is you look at a ground level and you see this whole pattern of crimes which low-level perpetrators are committing. And you may well say, well, if they were targeting particular groups of people whilst committing these acts, was it manifesting an intent to destroy the group, or was it just a discriminatory type of crime, such as persecution as a crime against humanity? And that was always the challenge at the ICTY of, was the intent to destroy the people that were targeted by the low-level perpetrators, or was it something else? And can even low-level perpetrators form an intent to destroy? Must it come from the top? So the Mladic judgment does something relatively unique in the sense that it assesses the low-level perpetrators for intent to commit genocide. It will no doubt be somewhat controversial. I can't say much more than that because I worked on the case, but it's currently at the appeal stage. But in the Mladic judgment, it was found that the low-level perpetrators in 1992, when crimes were being committed in a number of municipalities, that they must have had some form of intent to destroy, because the pattern of acts, the circumstantial evidence, the facts and circumstances of what was happening on the ground must mean that the low-level perpetrators had at least an intent to destroy in respect of what they were saying when they were carrying out these acts. Which then raises the question, well, if indeed that was the case, if that is beyond reasonable doubt, well, who was directing them? What about the mid-level people who were in charge of their units, police units or military units? What about the local mayors and officials who were in charge of those areas? And indeed, the next question is, well, what about the people at the top? How was it possible for state agents, officials, organs to be completely oblivious to the acts of their own armies and units? And indeed, the defense in Mladic and Karadzic argued, well, it wasn't us. These were just people spontaneously committing crimes. These were people who wanted to carry out revenge because of what happened to their own family members. These are people who were told not to commit war crimes, but they went out and did it regardless. And then think to yourself, well, how does an army or a unit or a police unit conduct a war without being led? How does it effectively retain control of a territory? How can you have anything happen without a structure and a system and procedures in place, which indeed many would argue there were by the forces that were operating. All three major armies had proper procedures in place to conduct operations as an army. So essentially what I'm saying is all of this raises far more questions than it answers, but those are practical considerations that you have to have in mind when we talk about genocide being committed or any other major atrocity crime.
And I think it's fair to observe, such is the complexity of genocide as a possible crime, that at any level of Aarif's three levels, well described, people could have or could not have genocidal intent without necessarily making it impossible to prove the contrary against the top or the bottom. The military commander, the political commander might have genocidal intent, but effect his genocidal intent by a military instruction that is not explicit about that. The military instruction carried out by the mid-level and bottom level might, in the individuals, have no such intent, but nevertheless, the overall operation will be genocidal. It is immensely complicated.
Well, yes and no, because what Aarif was saying about joint criminal enterprise, that is in ICTY, you have joint criminal enterprise level 1, 2, and 3, and it very, very clearly defines what it is. And if you want to understand these gradations, it's really enough to read few of these judgments, because I always do, and it explains lots to me. But to connect this, what you Jeffrey and Aarif just said to Holly's questions, she asked, obviously, how does this qualification of crimes for war crimes, crimes against humanity, and genocide play out in this system? So it plays out probably also from this perspective of those who pull the trigger, those who are, we call them mid-level linkage witnesses, and leadership people who have the power to plan and give orders and change the plans. And basically, you can have one killing in Srebrenica charged for the same person in one indictment as a war crime, crime against humanity, or genocide, but certainly someone who was on the ground or who was part of Srebrenica siege, you will have from one killing one person, you will have different qualifications in indictment, what it is, and maybe different confirmation and in a judgment, whether a killing is in a case of low-level perpetrator war crime. So what is important for us when you do investigations, prosecutors, when they compile indictment and when we lead evidence and then judges to look into it, is a test of proof. What is needed to prove from this killing whether it is war crime? If you have a ground soldier who just gave an order to execute a war prisoner, this is absolutely going to be, it's a classical example of breaches of Geneva Convention and a war crime. What you do, you are killing in a combat. For Geneva Convention, you have to have confirmation of armed conflict. So you as a soldier with a uniform, you are killing a prisoner of war. That's enough. This is a war crime, so you don't need to go further. But the same killing and execution for mid-level perpetrator could be crimes against humanity. Why? Because the person who is a little bit higher in understanding and having authority might well need the proof for crimes against humanity, which is widespread, is systematic. This mid-level commander is probably doing it for the whole area of Eastern Bosnia. And he has a different understanding of a conflict and different mens rea, criminal intent. So he's there to ethnically clean the whole Eastern Bosnia. But was someone who was sitting in Banja Luka or in Pale, like Karadzic at this moment, he was in some sort of church, I remember, with his wife, giving his reports what it was. It could be genocide because he, as someone with such a high authority, has been involved in had intent to destroy in part as a whole. And his premeditation and his power to implement this plan was obviously on a completely different level than a firing squad member who is executing a prisoner of war. And 4 important family of international criminal crimes, groups, families is grave breaches of laws and customs of war. So they're all based on 4 different conventions. And so you could actually see why this debate, how to qualify a certain crimes, depend on the level of the perpetrators and on their official and de facto authority, and test of proof is very clear. So someone can be acquitted of crime of genocide, which happened very often, and then being found guilty on for crimes against humanity for the same actual damages and killings. So Holly, I don't know if it explains your question, because you asked them this particular question several days before, but I thought it would be much better to deal with it when you heard many more about it. So it is test of proof needed to satisfy the judges when prosecution leads the evidence. And it is as important to take into account actus reus evidence, criminal act evidence, but it's essential to make this difference, how to qualify crime and prove it, on concentrating on evidence on mens rea, criminal intent.